Hello everyone, good evening. Can we all hear me? Hello, good evening. Can we all hear me? All right, thank you, Mr. Tauhid. Thank you all for joining. Welcome to class today. I want to welcome every member of this class. We are officially welcome to week 4 of the JIIPCC Mentorship and Internship Program for Entertainment, Business, and Law. Right, it's another wonderful day in class. Right, so please, I want to encourage all the mentees that are currently in session today to please reach out to other mentees that are not currently in class, or reach out to your subgroup so that we can have more people joining, because the session is officially starting now. So I want to thank our mentor for being in class today. I can see one of our mentors is already in session. Thank you so much, sir, for joining. We are happy to have you in today's session. And so I'll just be going through our agenda for today, what we'll be doing in class today. So like we always do, we'll be taking introduction. We'll be reading the profile of mentors, introducing them, and then we'll welcome the mentors. They will take their presentations, right? That is, the mentors that are in class will take their presentation. And after that, we'll be having presentations for the mentees. So please, mentees, do well to get ready for your presentation also, right? Both group 1 and group 2. After we're done taking presentations from mentees, we'll go back to the mentors for their feedback. And after feedback, we'll take questions, we'll take pictures, and then we'll call it a day, right? So let's just to quickly start off. I would like to we'll quickly run through the profile of our mentors. So I'll quickly start by reading Mr. Mr. Oluwaseyi Aruwosebe Shebe. Right. Thank you so much, sir, for joining. We're happy to have you in today's class. Sorry if my pronunciation of your surname might have not been correct. Sorry about that, sir. So Mr. Sheyi is the principal partner at the Lux Consult, a corporate and intellectual property law firm based in Abuja, Nigeria, serving clients across country and globally. The firm has advised hundreds of clients in the formation and maintenance of corporate entities, and also safeguarding the intellectual property of individual and corporate entities. He is a facilitator at the Intellectual Property Institute Nigeria, where he teaches trademarks and copyright. Sheyi holds a Master's of Law degree in Intellectual Property Law and Policy. He is also an alumnus of the prestigious Lagos Business School. We're happy to have you in the session, Mr. Sheyi. You are very, 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 very much welcome to class. Our second mentor we are also expecting in class today is Mr. Raphael Efe Irene. Mr. Raphael is an entertainment, media, and intellectual property lawyer. He is the founder of TEMT Africa, a platform that serves as a resource center and reference point for matters concerning technology, entertainment, media, telecommunications, intellectual property, and fashion in Africa. He was formerly an associate in the entertainment, leisure, and medial law business units of Olaniwun Ajayi LP, a multinational corporate and commercial law firm headquartered in Lagos, Nigeria. He was also an intellectual property, sorry, he was also an intellectual property and technology associate at AELEX Partners, where he's seconded as a legal associate to Prunage Technologies Developments Limited, an international technological service company also based in Lagos, Nigeria. He has advised a wide array of clients, including international and local clients, on intellectual property, technology, entertainment, and media matters. He is well versed in the realm of entertainment and media law. Mr. Raphael will be our second mentor for today. We hope he's able to join us soon. So, not to waste any of our time, saying that we already have one of our mentors in the session, we'll be going straight to have just today's discussion from Mr. Sheyi. Thank you so much, Mr. Sheyi, for being here. We'll just want you to just come and give us an introduction into the topic for today. And what are your thoughts about comedy skits and digital content? You're welcome, Mr. Shiri.
All right. Thank you so much for having me. Good evening. Please confirm that you have my audio loud and clear.
Yes, sir, we can hear you loud and clear, sir.
Awesome. Awesome. Thank you. Thank you. It's a very wonderful session. I look forward to comedy skits, guitar content creation is something that rides around everybody. Something we feel every now and then. It's something I consider a distraction if care is not taken. You find yourself reading, you find yourself studying, researching, or even sometimes in class, and then you mistakenly pick up your phone. Before you know it, you are on Brother Shaggy's page. Your macaroni, it could be Tao, it could be Brain Jotter, it could be the most recent series now, Governor Amuneke. So it could be any of those contents flying around, and then you find yourself sometimes lost in the web. 1 hour has gone, 2 hours has gone, but then that is the reality. But the background of all of this is that people are making a living from the content you consume. So one of the things I'm going to say tonight is for every time you spend being entertained on social media, either on Instagram, on Facebook, on YouTube, on TikTok, or whatever platform it is, as much as you are getting entertained, somebody is making some good dollars somewhere. That is the background I want to leave behind, such that you can also begin to think of how to make good use of the talent, the skills you have. You can start shooting content from the comfort of your hostel, of your home, or your office, or whatever it is you can call a comfort zone. So having said that, welcome to this session. I look forward to, of course, our presentations as mentees and the engagement that we would have afterwards. So proud to now, content, digital content were limited to what we saw on TV, on television, basically, until the introduction of advanced technologies by way of smartphones, by way of tablets, by way of MacBook, iPads, and all of the stuff. Of course, there was iPod in those days, yeah. So digital content came in, and then we had these gadgets in our pockets. Beyond the televisions that we sit and watch, you could now go about with loads of movies in your phone, and you could move around with a truckload of content everywhere. But like the background I was trying to make earlier is that it is business for the makers of those things. It is entertainment for you who is consuming, but it is business for the other person. Beyond being business for those people, there are challenges of people making use of some other person's work without authorization, and then we begin to look at infringement. But before we go into infringement, let us establish something that intellectual property is in the art of everything we know as comedy skits, as digital content creation. So it's all about IP. You have the copyright component. You have, I think we should just break it down into pieces. So we'll start with copyright, right? So primarily and traditionally, when you create content online, or when you create content anyway, music, poem, articles, short videos, uh, long movie, the moment these things are published, there is copyright, protection for it. That is the natural law of copyright. However, nothing stops you from taking extra steps to actually register your work at the Copyright Commission. It used to be notification, notify the commission of your work. But now the law has been, the act has been amended to show that truly you can register your work. But not everyone would, of course, take that long process because copyright is easy to make. When you write a poem of 5 lines, I like making this example all the time. You write a poem of 5 lines, as long as that poem is original, that's not been written before, you're not copying somebody's work. So the moment you have an original work and then you publish it, for example, on your Facebook page, on your LinkedIn or your Instagram or any of your social media, or you have a way to communicate it to the public, there is copyright in that poem. So imagine you're able to compose like maybe 20 poems in a week. Are you expected to register each of those poems at the Copyright Commission? So that is why the copyright regime is lenient, is easy. It grants protection to your work as long as it's original and you have fixed it, which means you publish it somewhere we can identify this work as a work of art. Somebody has made it. Okay, but then you can also always codify your work, your numerous poems into a particular volume of book and then publish all at once. That's why you have music artists today. They write 15 songs for an album, and then they have the option of registering that song as you can register those songs per track or register it all at once as an album. Okay, so digital content is something everybody is capable of creating, including everyone in this call right now. You can begin to create content today if you have not been creating, or if you're perhaps you're worried about how people will perceive you. Yes, perception is key, but if you don't start, you don't know. There are so many talents inborn that have not been explored. So I'm challenging you tonight to begin to look inwards and think of creating. Everybody is capable of creating until you start. You would never know. So that's for copyright components. I've talked about automatic protection, and then moving gradually to what happens by way of infringement. Somebody may copy a part of your work and then claim it is their own, or they copy your work and then they don't seek and obtain permission. That amount to infringement. But then somebody may come and say it is fair use because I'm just making use of it for the purpose of research. However, if you're going to enjoy the fair use window, there are a number of things that will be considered before it can be said that what you've done to the person's work amount to fair use and not infringement. So, what is the purpose for which you are making use of the work of another person? If you take the work of another person and you make economic benefit from it, it is no longer fair use. You make money from somebody's work, you deny somebody from enjoying the economic benefit of their work, and then you start enjoying it. It's not fair use. What is the nature of the work that you're or what is the nature of the product you make out of that work? So if you can tie it to research, perhaps you can let it go scot-free. But if you tie it down to commercial business, profit-oriented stuff, then you are caught in the web of infringement. Then what amount of content did you take from the original work? Did you copy verbatim? This is where plagiarism test comes in postgraduate schools, especially when you write your master's thesis in school. You're expected to subject your thesis to a test of plagiarism. So there's a percentage of originality that must be seen in your work. So if you cross a particular threshold, then you can't be allowed to proceed to rely on that research. Again, what is the market impact of the original work? If the work you have made out of the original diminishes the market impact of the original work, then yours can no longer be said to come under fair use. Now, how do you protect copyright? We've mentioned that it is in the first place automatic. The moment the work is created, it is original and it is fixed in a format, then it enjoys protection. But you can always take the other step to protect by way of registration, but not everybody would register their work. Agreed. But how do you protect digital content, comedy skits? If you observe some of the skits we watch, the artists would have their logo on one side of the work, on one side of the screen. You see Brother Shaggy's logo hanging somewhere. You see Brain Jota putting a watermark of his name on some of his skits. So these are also ways of protecting your work. And that takes us to the trademark consideration of digital content and comedy skits. So in protecting your work by having your logo somewhere, that logo is peculiar to you. The name is peculiar to you. Nothing stops you from trademarking that. Sabino's, all those Sabino's, like I said, Brain Jota, Brashagi as a logo of himself, hanging one leg and hanging one hand. I believe some of those things are trademarked. So when you see content in that regard, you can easily tell who is the owner of this work, no matter how anybody tries to paint it otherwise. All right, we'll move quickly now to imagine legal issues. Comedic skits. I'm aware today that some of the content we consume by way of entertainment are made through artificial intelligence, right? So some of them are not entirely human creation. We use machines to create some of these things. So the question now is, who enjoys copyright in those work? Is a machine capable of enjoying copyright protection? Are we going to uh, grant the right that should accrue to humans on machines? Because machines create, yes, machine create a whole lot these days now, a whole lot. So this question has been out there, and I'm certain it is subject to multiple debates. As to who should own copyright in a work that's entirely created by machine, artificial intelligence. But then we shouldn't forget also that there is a human factor behind the machine. Somebody operated the machine for it to be able to create that work. So this is one of the arguments that I may put forward. That the person behind the machine, the person who pressed buttons, the person who initiated the command for that machine to carry out that function may be considered as the owner of copyright in that work. All right. So talking about infringement is of copyright happens where a person performs any of the acts that the act restricts without the license of the copyright owner, or when there's no authorization to perform the infringing act under Section 36 of the Copyright Act. You can do a recourse to that section later and get the full gist of what amount to copyright infringement is in Part 4 of the Copyright Act 2022, 2023. Right now, where you have complaint of copyright infringement, there are remedies. You don't just go to bed or leave it to God. The remedies by way of damages, it could be general damages, it could be special, it could be punitive, it could be nominal. I believe you will learn more of this in your regular classes. I wouldn't take much of time. You could get injunction against such persons. You could get untemporary order. You could get an order for account for profit. And then there is criminal liability to copyright infringement. So it is not just civil wrong. It is a crime actually. The honest truth is that it is a form of theft, and stealing is a crime under our laws. So when somebody is found wanting of infringement of any sort of IP, it's a crime. So as much as it could be proceeded against in a civil court, it could also be reported um, for criminal prosecution. It could be investigation and all that. So, and that is why you observe, if you've read the Copyright Act, the Copyright Commission has police powers, to break into places suspected to be used for infringement purposes, to seize items, and then afterwards it could be criminal trials against anybody found wanting of infringement. Yes. Now, to conclude, so that we can give room for the intervention of your various groups and then to take questions and feedbacks, digital content creation is both creative endeavor and a legal minefield. By understanding the legal landscape, copyright, privacy, trademark, and advertising laws, creators can protect their work, respect the rights of others, and avoid costly legal disputes. As the digital world continues to evolve, staying informed and seeking legal advice when necessary will remain critical to thriving in this dynamic field. I go back to my introduction. Everybody is capable of creating content, digital content, and everybody also almost have access to consuming digital content. The average person on the street has a smartphone. Including if care is not taken, the people you call Mebola, all those waste collectors, some of them have smartphones. That is just an average person on the street. So everybody has access to data, to internet, to smartphones, so which means we are all naturally consumers. But some of us should also begin to delve into creation so that we can also enjoy the $1 trillion market around content creation. Thank you for listening. I look forward to the presentation of the groups and then the engagement that will come thereafter. Good evening, everyone.
All right. Good evening, Mr. Shade. Thank you for such a wonderful introduction into into our topic for today. We are really excited that you're able to share your thoughts with us in this line. All right. So before we get to our mentees, please, for the mentees, kindly do well to start getting ready so that immediately our second mentor is done. Once we call you up, you'll be able to start your presentation on time. All right. So please, we would want to quickly give the floor to Mr. Raphael. Mr. Raphael, I can see he's on the call if I'm not mistaken. Thank you so much, Mr. Raphael, for joining. We are happy to have you in today's session. Please, we would also want to just quickly hear from you in the next maybe 20 minutes or so. Just share your thoughts about the topic for today, that is digital contents, comedy skits and digital contents.
Yeah, good evening, everyone.
Good evening,
Uh,
sir.
so I know that everyone knows my name, but I believe it is imperative that I introduce myself. So my name is Raphael Irene. I'm a Nigerian corporate lawyer with expertise in entertainment law practice. So usually, whenever I get requests from J JIIPCC to come on board to lecture or to speak, it's always around music. I mean, that's my forte, but I also felt that the little knowledge I have about content creation, I can share with you guys. So yeah, um, content creation um, is actually not as old, or let me put it this way, it's actually a new form of entertainment. Uh, you can also argue that it is old, but I would say that it is a product of recent technological advancement. Before the advent of platforms like Instagram, Twitter, TikTok, even down to Snapchat, and even the current dispensation of streaming, internet streaming with Twitch and the rest platforms, we were not really, in fact, I don't think most people understood or heard of the term content creation. So you can clearly see that is a product of recent technological advancements. But then again, like I said, whatever is being done as per content creation is not new. The things we see when we watch content online, they are things that, in fact, most of them are already in place. But just that, what makes them the content we see is the reality that they are being conveyed to an audience through a social media platform. It can be Instagram, it can be Twitter, it can be TikTok, and all of that. Now, I understand that my topic dwells on the nexus between content creation and the law. So I would say that if you are into comedy skits, if you are into digital content, there are certain legal concerns that you have to take cognizance of. These legal concerns span they permit legal areas such as intellectual property, data protection, the law of tort when we talk about defamation, and even down to criminal law. So I will start with data protection. You know, we currently have the Nigerian Data Protection Act. That's the NDPA. What we used to have before was the regulations, but recently the NDPA came into force. And even before it came into force, there were provisions under the regulations and under extant laws that made it mandatory for you to seek consent when you make use of someone's data. Now, how does this pertain to content creation? When people put out content, the content they put out involves a lot of things. And most times, in fact, sometimes they make use of data. You understand? So if you are referencing the personal information of somebody, you have to understand that you need to have sought the permission of that person. It's not just enough for you to credit the person like most people do in our client. You needed to have obtained the permission of that person before you reference the personal information of anybody in your content. You understand? So you can't just record a video, record the content, even down to podcast, the podcast that we listen to. You get, if you are invited to speak during the podcast session, you have to ensure that whatever information you are revealing while speaking does not in any way impact the privacy of any other person. Mind you, data protection laws do not, as a general rule, um, they do not cater for corporate institutions, corporate entities, institutions, and all of that. They are mainly data protection laws are mainly concerned with individuals. So you have to be very careful as a content creator when putting out your contents. You have to ensure that you do not put out content that reveals certain personal information, thereby breaching the data privacy rights of others, of other individuals. Now, with respect to intellectual property, sorry I'm talking this way. I had an accident a few days ago, so I'm supposed to be resting, but I had to come on board. Now, with respect to intellectual property, the contents that we put out on social media and other related platforms, even down to YouTube, Spotify, and you can upload podcasts on Spotify. You can listen to podcasts on YouTube, on Apple Music, and the rest. Now, you see those contents there, they are afforded protection under Nigerian intellectual property laws. So first of all, they are regarded as copyrightable works. I think Section 2 of the Nigerian Copyright Act, the recent Copyright Act, makes provision for types of works that are eligible for copyright protection. Now we have literary work, artistic work, musical work, audiovisual work. We have broadcast. Then one last one. Pardon me, that has escaped my mind now. But with respect to content, you would observe that recently, I mean, in these new acts, there were some changes that were made. If you place this new act vis-a-vis the old act had what we call cinematograph film, but this new act now has what we call audiovisual works. So one of the reasons behind changing cinematograph films to audiovisual works is to accommodate all forms of videos, all types of videos, including content that are uploaded on social media. So what this implies is that it used to be a question of debate. It used to be a debate as to whether social media content and skits are eligible for copyright protection, given the definition of cinematograph film under the erstwhile Copyright Act. But that argument is no longer there. Currently, under audiovisual works, social media contents are now automatically eligible for copyright protection. And like the first speaker mentioned, you don't need to do any special registration to be able to protect your copyrightable work. However, you can do what we call copyright notification. It is just to notify the Nigerian Copyright Commission, the NCC, that the copyright in this particular work belongs to you. But I don't see skit makers doing this anyway, except it's a very special skit. You understand? And I also believe that beyond copyright, another area of intellectual property that we should also be concerned about when it comes to content creation is trademark. And this is because some contents have special names. So it is imperative for those names to be trademarked. For example, WAP TV, Wale Adenuga Productions TV, they have a program called Akpan and Uduma. They also upload that program on their website, on their YouTube page. So the name Akpan and Uduma, it's a thing of it's a thing of I don't know what to say, prudence to trademark the name Akpan and Uduma ahead of time. You understand? You have to be a very prudent person to think of trademarking the name, which is actually very good for you, for your brand. Now, same thing with visa on arrival. You understand? So that other people do not start using those names for their own content too. So it is very much imperative. It is very, very germane for you to trademark the title of your content, particularly if that title is the title that will apply to all of the contents that you're putting out. Always trademark the title. And it's not just trademarking the title alone. It is also imperative that you trademark the title along with whatever logo you have. Visa on Arrival has a logo. I think so. Akpan and Uduma has a logo. So you would trademark the logo as a wordmark to ensure and guarantee its continued protection. Then with respect to law of thought basically has to do with when you mention law of thought, you talk about defamation. Defamation is under law of thought, although there are people that will tell you that there is something called defamation law. I'm not here to argue about that, but I always like to classify it under the law of thought. So when you put out content, as much as it is important that you are not infringing on the privacy of others, also ensure that your content is not defaming the character of other persons. You understand? And sometimes it is difficult to, the line between fair use, fair dealing, and actually defaming people is quite blurry. The line between justification too, justification is a difference for defamation. So if the difference of justification, so it's always very blurry. You understand? So you have to ensure that, okay, whatever you're doing, whatever content you're putting out, does not at the end of the day defame the character of any other person. If not, you'll be liable. And also ensure that the content you are putting out is not, and this has to do with cyber crimes now. You're not cyberbullying another person. It's very much possible to use your content to be a cyber bully. You'll be using it to taunt other people. You'll be using it to mock them online, so that they won't have rest of mind. They won't be able to use the internet freely without consistently thinking or worrying about the nonsense that you're doing or that you're putting out. Then the criminal aspect of it, yeah. So because of the reality that defamation can also, in some crimes, defamation can be of a criminal nature. Copyright infringement can also be of a criminal nature, depending on how it is classified. Then cyberbullying, obviously, cyberbullying is of a criminal nature because the law that prohibits cyberbullying the law that prohibits cyberbullying is the Cybercrimes Act of 2015. So it's an act that prohibits offenses in general, cyber offenses in general, and cyberbullying is classified as an offense. So yeah. So that's it. That's it basically. With respect to the criminal aspect of it, criminal law aspect of it. So yeah, I'm done. I await your questions now. Thank you.
All right. Thank you very much. Thank you very much, Mr. Raphael. So I don't know, Mr. Raphael may not be able to stay very long. So please, if there is any question that we have for him, can we quickly ask, right? So that, in case if, there's any question that is directly targeted to him, he can quickly answer before he has to go off the call. Do we have any questions for Mr. Raphael? That's before we get back to presentations. Okay. Somebody is asking if dance steps can be protected. Hello, Mr. Raphael.
I had no idea that I was muted. Sorry. So if dance
All right.
steps can be protected. Hello?
Yes, sir. That's the question from Jennifer.
Okay.
Like viral steps can be protected.
Okay. So I think that's a very dicey question. But I don't think it can be protected. If we look at copyright will not protect it. Trademark also will not protect it. Now, with respect to patents and design, I would say patents protect inventions. So the question then would be, by what metric is a dance step an invention that is protectable, or that can be protected rather, under extant laws regulating patents? You understand? So, well, I would say it is arguable that it can be patented anyway, but I don't see the registry granting a patent for dance steps. The requirement alone for patenting anything in Nigeria and in other climes, like, the requirements are very, very strict. So it will be very dicey to see that happen. Yeah, so that's my opinion on it.
All right. And then there's a second question still from Jennifer. She's asking, do you think the laws are enough to protect these content creators?
So they are not. I don't think they are exhaustive. I don't think the laws are exhaustive. If we look at the reality that we do not have standalone content, like laws that are standalone laws, get solely towards protecting, content. You understand? The laws that govern that govern content creation in Nigeria are laws that can be found in other areas. They are not laws that exactly protect content. You understand? Just the same way we have intellectual property now that protects intellectual property, right? Intellectual property laws like Copyright Acts, the Patent and Design Act, the Trademarks Act that directly protects intellectual property. There are no standalone laws that protect content. So I believe that on that basis, it is arguable that the laws that protect content creation in Nigeria are not exhaustive. So we most likely need more laws. But then again, my fear is if we make more laws to protect content creation, we might end up creating a barrier. We might end up creating a clog on the ability of content creators to make their content. You know, content creation is premised on the freedom of expression. So if we end up making more laws to regulate content creation, we may be stifling that freedom of expression at the end of the day. And it wouldn't make more sense, particularly in a climate like ours. Nigerians don't know how to make laws to help people. More often than not, laws are made to destroy than to make. So yeah, that's my opinion on it.
All right, thank you so much, Mr. Raphael, for helping us tackle those questions. I think other questions will be addressed to Mr. Shea later on in class, right? So, but just for continuity sake of the session, we would want to have quickly the both groups present so that we can move back to the mentors and then we can fully go into our question and answer segment. So please, group presenter for group one. Please, you have 10 minutes for your presentation. Kindly do well, share your slides, and then start your presentation while group two also gets ready. So can we have the group presenter for group one? Do we have the group presenter for group one?
Yes, good evening, Mr. Williams. Good evening, everyone. My co-presenter is supposed to share her screen to assist me in sharing her screen.
Okay.
Mr. Williams, please can you assist us in sharing the slides?
Okay, I'm coming. I will do that right now. Give me a moment.
Thank
I'm
you.
trying to bring it up. This is for group one, right?
Yes, group one.
All right. Sorry, just one more minute. I would be drawing it up right now. All right, you can go ahead.
Okay, thank you very much, Mr. Williams. Okay, good evening, everyone. My name is Daniela Igoma, and today I'll be presenting on behalf of Group 1, and we'll be presenting on comedy skits and digital content. So we'll be going on the world where creativity meets law and how entertainment becomes a business. So we're going to explore how comedy creators protect their works, earn from it, and navigate the digital space. So on slide 1, we can see copyright is the most relevant IP rights for skits and digital content. A script or a joke is literary. A performance is audiovisual, and a recording or a sound is IP. So slide 1 basically is saying intellectual property or IP, as we refer to, is the creation of minds. So a comedy script or a video or even a character is IP. So in Nigeria, the Copyrights Act of 2022 protects these works. So automatically, if I were to write a script or a skit and post it online, I own the copyrights. So this means no one else can legally copy or repost or monetize my work without permission. So if someone then downloads the skits, maybe I post a skit on TikTok and someone reposts it on YouTube to earn money, that's copyright infringement. Please, the next slide. So trademark. Trademarks are about identity. What makes your brand unique? It could be the stage name, logos, even slogans that identify your brand. So for example, we know Funke Akindele trademarked Jennifer, so no one else can use that name for a show or product. And the name she trademarked was with a different spelling, that's JENIFA, has been trademarked by Funke Akindele. So a good example here, like I just mentioned, so if your comedy brand becomes popular, and then you go ahead to want to trademark it, this ensures that others cannot hijack your identity or confuse your audience. Please, the next slide. So basically, trademark is just ensuring that it protects your brand. So patents. Patents protect inventions. So patents are less directly connected to skits or comedy, but they come into play when innovation is involved. So they apply if you create a unique app, an editing tool, or camera setup that others want to use. So this is where patents comes into. It is not common in comedy. So, for example, if you invent a new way to live stream your skits with maybe an interactive feature, you can now patent it and license it to other creators. So that's where patents comes into play in comedy. Please, the next slide. So contracts for content creation and licensing. So contracts are the backbone of content creation and distribution. Contracts outline exactly what the content is to be made, the formats and the deadlines. So like we know that contracts are written agreements. So these contracts define the ownership, payment and the usage of the rights. So now looking at licensing. Licensing here allows you to give others the permission to use your content while you still own it. So for example, you license your skits to Netflix for 6 months. They pay you, but you still own the content and can license it elsewhere. So that's basically the licensing. Please, the next slide. So talent agreements. Talent agreements apply to the comedians, actors, or performers featured in digital content. So when you work with an actor or collaborators, talent agreements clarifies these roles. It clarifies the payments and behavior expectations. So this agreement just comes into play on how to ensure that everybody is clear on their role in this creation we are making. So this talent agreement allows you to know the end of your contracts and to know if when someone, maybe an actor, is acting outside his or behaving in a way that then intends to damage your brand, like getting involved in a scandal. So if this were stated in the contract, the talent agreement, then definitely you can seek damages. Please, the next slide. So rights clearance in comedy skits. Comedy often borrows from popular culture, which makes rights clearance very important. Using music, clips from videos or viral videos usually requires a license. So to say, comedy often uses, like, some comedies we watch, we can see that sometimes they use music in their comedies, maybe memes or brand names. So you need like permission. You need permission to use this, or you risk being sued. So, for example, using a popular song in a skit without permission can get your video, or can lead to your video being taken down or being demonetized, like how YouTube does it. Please, the next slide. What is fair use? Fair use is a legal defense that allows limited use of copyrighted works without needing permission. It is the purpose to balance rights of creators with public benefits like education, commentary, news reporting. So courts would weigh these factors, weigh the purpose and the character of the content you're using. If you're not infringing on copyrights. So fair use basically lets you use small parts of these copyrighted materials, maybe for commentary or educational purposes. Please, the next slide. So parody. A parody imitates an original work to poke fun at or criticize it. So basically, parody mocks the original. For example, Spaceballs parodied Star Wars by copying characters and style by twisting them into humorous forms. So this kind of use is generally protected as fair use. Please, the next slide. Satire is different from parody. Instead of mocking the original work, satire uses it to make a point about something else. So basically, is like using satire to comment on something. Like, for instance, South Park often borrows from video games or films, but the real commentary is on a broader issue like media, culture, or politics. Courts are stricter with satire because the borrowed work isn't essential to the message. It could have been made without copying. That's why satire is less often protected as fair use compared to parody. So, for example, if you imitate a politician's speech to make fun of it, that's parody, and it may be protected. But if you use a speech to criticize the society, that's satire and less protected. Please, the next slide. So the next slide is talking on copyright infringement, which is authorized use of copyright holders' work. And we know that the Federal High Court has jurisdiction to hear matters, to hear IP matters. Please, the next slide. Okay, next slide here is on the fair use and parody in infringement defense. Like I said earlier, courts are likely to accept a parody than a satire, and fair use is a defense against infringement. Please, the next slide. Licensing strategy, like we have said, comedy skits can be licensed to platforms, and is a way where creators make money from licensing. Please, the next slide. And distribution agreements for digital creators. This define how and where the comedic content reaches the audience. So it still goes back to platforms like YouTube, Iroko TV, and the likes. So creative control is also negotiable. Like when Coming to America went to Amazon Prime during COVID-19, and also cuts in both the US and Nigeria recognize and enforce distribution rights, ensuring that these creators are not exploited. Please, the next slide. Okay, monetization models for comedy content. So how how creators make their money? Monetization. So comedians diversify their income through different models, like ad-supported models, like through different ways. Like creators earn through sponsorships, subscriptions, and even licensing too. Because like YouTube now pays for views, and brands also pay for product placements in these comedy skits that we watch. That's why when we see some comedy skits like Sabinus and the likes, we get to see that some brands will pay for their products to be publicized or their app to be publicized. So this is how like these creators earn money too. And platforms too also pay them for exclusive rights. Because when these creators put their creation on Instagram, TikTok, Facebook, these platforms pay them. Like we have on the slide, Mackenzie earns from YouTube ads. Trevor Noah earns from Netflix specials. Kevin Hart even built his own network to combine multiple income stream. So this is how like these creators get their money, make their money, and monetize their content. Please, the next slide. So the platform rules. So basically, the platform rules are when you upload a content, you agree to these platform rules. So these are the rules that are like stated when you want to upload, and these rules can change. And then when these rules are violated, can lead to your account being deleted or demonetization of your account. Like content creators go through these challenges. And a problem we have in Nigeria is that we don't have like a DMCA style law to protect these creators from unfair takedowns, because sometimes Instagram can just decide to take down maybe Tunde Not's page, and then he has to start all over again, trying to get back his followers. And so sad, Nigeria, we do not have laws to protect creators from these unfair takedowns. So if the skit is removed, we have no legal recourse. We just have to start all over again. So I would recommend that what creators should do, they should keep records of the rights clearance and contracts. These platform rules and terms should be carefully read before being uploaded, and they should diversify platforms so not to just depend on one. Because if they have like other platforms, maybe you have different pages on Facebook, Instagram, TikTok, and if one is being taken down, they can just post on the other, and followers from that social media, from Facebook, and then just help them grow back their Instagram accounts that they are starting afresh. So I would recommend that creators should ensure that they push for more accounts and not just depend on one, and also push for better laws and have backings of lawyers that can explain to them on their IP rights. So in summary, I would say comedy skits are more than just laughs. They are more than just there to entertain us. They are intellectual property, business assets, and cultural tools. So by understanding the legal and commercial side of digital content, creators can protect their work and earn fairly and grow sustainably, and not be cheated or not have where to be backed when their copyrights are being infringed or their creations are being used without permission. Thank you very much. I've come to the end of my presentation.
All right, thank you, Daniela, for your presentation. Well done to you and to the members of Group 1 for putting it together. We really appreciate the efforts and the time it took for your group to do that. So well done once again. All right, so please, can we quickly have Group 2 come up and make their presentation? Let's be snappy with it so that we can go back to our mentors, get their feedback, and also just continue with the discussion. Can we have the Group 2 presenter? Can we have the Group 2 presenter quickly? We'll be taking your presentation now. Please do well to share your screen and let's start your presentation. If the Group 2 presenter is not on call, can we have a member of the group step in to fill in that position? Let's be snappy with it. Thank you all. Like I said, if the presenter is not in class, right, we have an obligation we can actually step in on behalf of the presenter. And if you need assistance with sharing the screen, I can do that on your behalf. So let's quickly get on with it. Do we have members of Group 2 in class? Please, we would like to quickly do that.
Good evening, sir. Good evening, Fabula.
Good evening, Mr. Tohid. You'll be stepping into my presentation on behalf of Group, right?
Yeah. I'll be stepping up to make it. Can you please help with the slide?
All right, please give me a minute. Let me share your slides for you. All right, you can go ahead, Mr. Tohid.
Yeah, thank you so much. Good evening, everyone. My name is Taib Abdulsam Madabasoda, and I'm stepping in to present on behalf of Group 2 on the topic comedy, skit, digital content, and content creators. Well, the second slide, we have our table of contents. Please, the second slide, please. Yeah. On our table of contents, we have privacy and defamation, which should be discussed. We have content creation ethics. We have digital security and privacy. We have emerging technologies. We have international consideration, which will surely be discussed. The next slide, please. Yeah. Firstly, privacy and defamation. As we all know, privacy refers to the right in which an individual has to control personal information. That is the kind of fundamental right which an individual wish you have to control some information that are only private and personal to you. But on the other hand, information is making false statements that forms a person or that in one way or the other affect a person's reputation. Now, there are some things we should know from this privacy and information. First one is that protecting personal privacy rights when creating comedic content. That is, in a situation, since this topic is related to comedy, so we have to link the definition, that is privacy and defamation, to content creation. Now, since content creation or comedic content in one way or the other have a kind of, or in some ways, can say, have some aspect or some some aspect of personal information. There's always this right that it is better for the privacy and private or personal rights in which a person has to be protected. Another one which is to be take as a take home is that defamation laws and avoiding liability for defamatory statements in digital content. We have defamation law in places, a lot of them. However, we should also know that while ensuring that privacy and defamation are protected, we should know that in a situation whereby a person who intends to have a kind of comedy or you want to produce a kind of comic act, you should ensure that defamation are well protected, and also liability for defamatory statements in digital content also should be considered. Another one, which is the last in the third slide, is that handling legal challenges related to invasion of privacy claims. Now, the next one, which is content creation ethics. We should note that ethics in content creation means applying moral principle to ensure that fairness, respect, and responsibility in producing digital work. That is, it is kind of moral. It's a kind of fairness in people. But while creating that your content, you should ensure that there is ethics in it. Now, the take home here is that ethical consideration in comedy and satire content creation, that is, you should also consider as a content creator the ethics, or you should also consider the moral being. You should also consider fairness while creating your content. Another one is that avoiding offensive or controversial material and potential legal consequences. That is, while producing your content, you should ensure that any form of offensive words, any form of controversial action, or even material should be avoided at all instant. The reason to avoid this or for avoiding this is to prevent potential legal consequences or legal action. Another take home is that navigating cultural sensitivity and diversity issue in comedy and digital content. Another ethics we should be considered, as I said, is that there are people who are very, very sensitive to cultural stuff or diversity issues that might affect human being. When you are a Yoruba, you are making a comedy abusing the Igbo people, abusing the Hausa people. It is something that can awaken the cultural sensitivity of people and also the diversity of people. The next slide, please. The next slide is on digital security and privacy. As we all know, digital security involves safeguarding online content, while privacy is the unauthorized use or distribution of another's creative work. Now, digital security, as the names imply, is the art of protecting, safeguarding content that are made by people online. Well, piracy, as I said earlier, it is basically a kind of it is a crime. Yes, it is a crime, and it means when a person use or distributes another creative work which belongs to another person in an unauthorized way without getting the full consent of the owner. Now, the take home here include protecting digital content from piracy and unauthorized distribution. That is one. That is, for a content creator or for anybody who is intending to create any art, you must ensure that you protect the digital content from all forms of piracy and unauthorized distribution. And that one is implementing digital rights management, that is DRM system for comedy and skit content. Another, which is the last, is the legal remedies for combating online piracy and copyright infringement also should be considered. The next slide, please. The next slide is on emerging technologies. We all know that technology has now taken over the world. everything starting from all aspects, basically banking, law, finance, all aspects has been taken over by technology. Now imagine technology, there are like new innovations like AI, artificial intelligence, virtual reality, that is VR, and augmented reality AR, that transfer digital content creation. Now, the take home here is that we should consider the legal implication of AI-generated comedic content and deepfake. That is, the legal implication of these things should be considered. Another one is blockchain application for copyright management and digital content ownership. We all know blockchain. It is a kind of a an AI. Yes, it's blockchain. Basically, it basically means a kind of public chain or chain of block, basically from its name, whereby there is a kind of freedom for people to put to work on it. So in such a way, since it is public, it has no restriction generally in nature. So there will be an issue between blockchain, its application, and also the copyright application of it. Another one is on the regulatory challenges and opportunities in virtual reality, that is VR comedy experience. Now, international consideration. The last slide, please. Now, international consideration, they are like the global legal and cultural factors which influence how digital content is created and shared across borders. Now, the take home here is that first, there is a kind of cross-border legal issues in digital content creation and distribution. I asked a question initially as regards whether or not there is this jurisdictional or territorial restriction as to content creation, that is the law guiding it. So all this should be considered. The cross-border legal issue, whether or not content creation, once it is protected in a particular country, the protection will also extend to another country. Another is harmonization of intellectual property law for global comedy and skit creation. And lastly, strategies for enforcing intellectual property rights in different jurisdictions. So thank you so very much, everyone.
All right. Thank you so much, Mr. Wahid, for stepping in to present for your group. We really appreciate the efforts. And also, please, to the group members of Group 2, please let's try and ensure that we are on board to make sure that presentations are always ready to be taken in class. So we'll be going back to our mentors, Mr. Shei. I can see you're still with us. Thank you so much, sir, for staying back up to this time. Please, sir, we just want to quickly hear from you, share your thoughts about the presentation, your feedback, and also any other thing you would like to add in terms of contributions to the discussion on comedy skits and digital.
All right, many thanks to the presenters of the two groups for their presentation. I enjoyed the classes today. I see that we're beginning to speak to our work in previous sessions on this kind of call. We have persons coming to basically read to us what they've done, but from tonight, we have people speaking to the content they've created, speaking to the research they've done over the few weeks that have passed. So many thanks. And then flowing from the conversation, I saw it was as though we were divinely led to have Group 1 present first and then Group 2 doing following serially. There were no much of similarities in the presentations, which means research were truly independently done by each of the groups. Then the work of Group 1 looked to me like introducing us to the subject we were talking about, taking us through the various IP components of comedy skits and digital content and all that. And I saw also how much Group 2 took us to the higher pedestal, introducing the cyberbully angle, the privacy angle, the blockchain angle to all of the conversations we are having. So by and large, I celebrate the work we've done. I like to keep this short so that we can engage further through your questions. Thank you.
All right, thank you so much, Mr. Shea, for the feedback. So we'll be going straight to questions. We'll be going straight to questions now. So please, if we still have more questions, let's do well to ask. But before we take more questions, I think there's a question on the chat box from Sohid that he asked earlier on. The question is the protection of contents jurisdictionally restricted to Nigeria, or once it is protected in Nigeria, is presumed to have been protected in all other countries?
Right, thank you for that. So
Did you get the
general
question,
rule,
sir?
I did. The general rule is that IP protection is territorial. And how do we mean by that? Let's take, for example, trademark registration. When you register trademark for your brand in Nigeria, the protection is limited to Nigeria. But when you register your trademark in accordance with international treaties, you can begin to consider registration across one country. For example, there is the ARIPO that covers some English-speaking countries in Africa. And then there is the OAPI protocol that covers these French-speaking countries also in Africa. I think each of them has between 17 and 13 countries across board. So when you register your work through any of the international protocols, you can rest assured that you have international protection in the number of countries applicable. But if you register in a single entity country like Nigeria, for example, then you're limited here. Recently, we did trademark registration for a client of ours, is in fact in WAPI and ARIPO respectively. So we have a number of African countries that have been taken care of with just 2 registrations. Now you can, if you want it on a global scale, you have to go through the WIPO protocol to register your work. But primarily, the answer is that corporate protection and IP generally is territorial. So it is the places, the countries, number of countries, or under what treaty you register your work that you enjoy protection. For copyright, which is natural, which is automatic upon creation and originality, sorry, upon originality and fixation, you are covered in Nigeria. So when you shoot your skit, your content, you enjoy protection here in Nigeria. It does not necessarily mean that somebody in UK watching your skit can infringe on your work, but enforcement might be an issue. How do you begin to drag somebody in US for copying your work and reproducing it? Don't forget that we also get many inspiration from content that are shot abroad that we see. There are many comedians that are skit makers that some of our people in Nigeria see their skit and then they replicate some of those skits here. Beyond skits, even music, I can count on a number of Nigerian music artists who see artists from US, from Spain, from other countries, and then they find a way to recreate those songs. I won't mention names, but I know a number of them are ranking in my head right now. And they create those songs to make it look like an original work. But if you have experience with content out of Nigeria, you can tell when your favorite artist in Nigeria is copying somebody or is sampling somebody's song. That's just by the way. Thank you.
All right, thank you very much, Mr. Shea. Please, do we still have more questions that we would like to ask? Please, I encourage us to take advantage of this question and answer segment to try to get the best out of this session, right? So that you can also gain more in terms of knowledge. So please, if you have questions, you can indicate by raise of hand, or you can send your questions into the chat box. But before while we are taking questions, I think I would like to ask a question for my own self, right? And my question is, sir, with most content today, contents are mostly also used for marketing purposes, right? There are a lot of content makers or skit makers that use brands to or use certain brands or advertise for certain brands using their content. So I want to ask if those skit makers are liable when they display certain brands that they do not receive consent for to use those items within their skits. I know in movies, right, many movie production industries go like a very long way to get permission before they display certain brands. And even in, I think abroad, some people trying to avoid even paying for those things, they create their own, they create or innovate their own things to add to movies to avoid displaying those brands. So are there liabilities to content or to skit makers who display brands that they are not outrightly advertising or giving any reference to?
Absolutely. If you make use of the work of anybody without seeking and obtaining license, you can be liable for many things. I give a live example. Sometimes last year or the year before, a colleague of mine sent an SOS message. It was Tao and Folagade who did a skit, and they portrayed the bread, the product of the father of this colleague of mine as a bad bread, as a bad product. And they were careless enough to show the logo, the brand of that bread. I mean, it is public knowledge, Weko or something in Lagos. The moment that skit was released, somebody reached out to my colleague and said, see the recent post, the recent skit released by Tao and Folagade. And then she reached out to me and they're like, well, something has to be done. Since I was the IP person that they know. So I did the letter immediately. I mean, I think that day or the following day, we did the letter to them and letting them know the harm, the damage they have done to the business of our person for shooting a content, making it look as if the bread is bad. Even if they did not mean it, you can't just take somebody's product and cast aspersions in the name of content creation. So I tell you what, they took down the post on all the social media, all everywhere they published it, they took it down, and then they had their own lawyer. It was Tinekwaji that wrote in return, I mean, in reply to us, saying they didn't mean that, blah blah. So we found a way to resolve it. So what are we saying? If somebody takes your product, your brand, to shoot content in a way that denigrates your brand, that spoils your work, it is wrong. It is harmful. It is very, very wrong. You can't just escape it. Imagine somebody wakes up today and starts throwing shades at Dangote cement in the name of content creation. You carry Dangote cement, the bag, you show the logo, show everything, and you start doing nonsense on top of it in the name of content creation. No, the man will not leave you to just go saying you are creating content. No, they will deal with you. Brand go extra miles, extra length to pay influencers, to pay skit makers, to portray their business, to portray their product in good light. So they pay heavily to for one XBet, for each of those skits you see, all these content creators making mention one XBet, they pay heavily for them. So you shouldn't wake up one day and start doing damage to somebody's brand, maybe because they're not paying you or because you are just shooting skits. It is wrong. You can be held liable. Thank you.
All right, thank you so much, Mr. Shea. I just see any more questions we would like to ask just before we call it a close on class. Please, if you have any question, feel free to ask. Right,
While we
feel
are
free
still
to
thinking,
ask.
while we're still thinking of possible questions, I'd like to share my thoughts on the earlier question that was sent to my colleague on the speaking team tonight about whether a dance can be protected with IP. My immediate response is yes. I can explain that. For every creativity that has been expressed, it is no longer an idea. It's an idea if it is within you and you have not expressed it. But the moment that idea has been expressed in a format that you can see, that we can feel, that we can appreciate, and it's original, it is capable of protection. If you recall, if you study copyright to an extent, there is performance rights. Somebody sang a song, that's the writer, somebody performed the song, somebody produced the song, somebody mastered the song. So there are many rights that can emanate from a particular IP. I think we said that earlier today. So if you perform a dance and that is the first time that dance is being performed, you can protect the dance. For example, we must have heard of salsa dance or bata dance. Now, salsa is said to have drawn sense from bata. Bata is Nigerian. Bata is our dance here. Salsa picked up and then they're trying to fine-tune it to make it their own. It's actually local to Nigeria. So if something can be known to that extent, then a dance can be protected. Now, how do we protect dance? Again, IP goes beyond the four popular forms that we know: copyright, trademarks, industrial design, and patents. There is the traditional knowledge, there is the plant varieties, and then we have folklore. So you don't necessarily need to protect dance through any traditional forms of IP that we know. You can come under geographic indication. So if a dance is known to a particular place, so be it. So salsa dance is known to a particular country abroad, yes, but we've also agreed that it drawn inference from bata dance, which is local to Nigeria. So there could be a dance that is peculiar to the people of a country. Like I was in Kigali recently, and I saw some dance that I've not seen before. And everybody agreed that yes, this dance, it is peculiar to Rwanda. So a dance can be peculiar to a location, and then you identify that location as the owner of that dance. So to that extent, you can protect a dance. Just make sure it is original. Before Awilo dance came, was it danced anywhere? But Awilo released the song and then the video came out and then that was the dance that flowed with it. So you can link that dance to Awilo song and then you can dig further to find out who created that dance. So yes, dance can be protected. Thank you.
All right, thank you, Mr. Shea, for shedding more light to that initial question that was asked. So I haven't noticed any more question. I want to assume that, as pertaining to this class, we've gotten the milk and meat of this session, and we've been able to ride through everything our mentors have shared, including the presentations and everything that was said in them. So please, I want to encourage us ahead of next class. Let's come prepared to class with questions. Let's ensure that we are ready to ask questions, because that's one of the ways we facilitate the sessions in such a way that both you and the mentors get engaged, and we are able to have a discourse that may not have been shared during the mentors presentation. So please, let's come to class prepared to ask questions. Thank you so much, Mr. Shea, for being with us today. We sincerely do appreciate your time and your shared knowledge in today's session. We also thank Mr. Raphael in Essential, right? And I think with that, we've come to the end. Okay, sorry, I just forgot. Before we go, please, for those who have some kind of light in their background, my video is turned on my other device. Please, can we quickly turn on our videos so that we can take pictures? Mentees, please, can we turn on our videos so that we can take pictures? Thank you so much, Mr. Tohid. All right, can we have more mentees turn on their videos? Thank you, China Loom. We'll be doing that in a minute. Please, can we have more people turn on their videos? Thank you as you cooperate. All right, it's nice seeing you, Emanuela. Okay. All right, so we've come to the end of today's session. Please do not forget to share what you have learned on your different social media platforms. Do not forget to share what you have learned on your different social media platforms. Do not also forget to tag our mentors so that they can see that you have learned from them in today's session. Please do all enjoy the rest of your evening. To Mr. Shea, thank you once again for your time. Good night, everyone, and God bless.